All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning, everyone. Could the court officer please call the case? Thank you.
Good morning, Mr. President, Your Honors. Situation in Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115, and for the record, we are in open session.
Thank you. I would like to welcome everyone in the courtroom for these closing statements over 3 days. And I invite the parties to introduce themselves. As we start, as always, with the prosecution. I assume Mr. Gumpert.
Thank you, Your Honour. Ben Gumpert for the prosecution. With me today, Adeshola Adeboyejo, Colin Black, Betty Hota, Pubudu Sachitanandan, Colin Gilg, Haido Duk, Nicola Kaushik, Shkelzen Zanelli, Julian Nusban, and Grace Go.
Thank you. And for the legal representatives of the victims, Ms. Masida first.
Good morning, Mr. President, Your Honors. For the common legal representative team appearing today, Mr. Orcholona Ransetsek, Ms. Caroline Walter, and I am Paulina Masida.
Thank you. And Mr. Manoba.
Good morning, Mr. President, Your Honors. Today with me is Listo Ato and Francisco Cox and Anushka Semi. Thank you.
Thank you very much. And for the defense, who is rising? Mr. Ayena is rising. Then for defense, Mr. Ayena.
Good morning, Mr. President and Your Honors. Today I'm accompanied by Chief Charles Acheleka Tako, Beth Leons, Kifude Gordon, Thomas Obov, Thibaut Bainovich. We have Eniko and Michael Rouse and Madame Morgan. And in court, we have our client, Mr. Dominic Ongwen.
Thank you, Mr. Ayena. And as a short reminder for the schedule for the public for this week, we will have this week every day closing statements. Today, the whole day, the prosecution. Tomorrow, the representatives of the victims will have each one session. And on Thursday, for the whole day, we will hear the defense's closing statements. We give now the floor to the prosecution for their closing arguments, statements, and I assume I give the floor, Mr. Gumpert.
Thank you, Mr. President. I want to make it plain that in the submissions that we'll be making today, the prosecution isn't going to attempt to encapsulate the whole of its case against Dominic Ongwen. The prosecution case is set out in the 200-page written brief, which we have filed, and that brief is available to the public. The principal purpose of the remarks that I'll be making today is to deal with issues which arise out of the written brief which the defence have filed. Let me briefly describe the structure of the prosecution's submissions today. First, Mrs. Adeboyejo will be speaking about some of the issues arising from the defence brief concerning the crimes which the prosecution allege Mr. Ongwen committed, of which the victims are the 7 women whom he regarded as his wives during the charged period, women who've given evidence about their experiences of forced marriage, rape, sexual slavery, and other sexual and gender-based crimes at Mr. Ongwen's hands. Next, I shall speak about the allegations that the defence have made concerning the alleged unfairness of this trial. I'll speak about their observations concerning the modes of liability which may attach to Mr. Ongwen, about their suggestions that the Chamber shouldn't rely upon evidence of the LRA's intercepted radio communications, and about their submissions concerning mental disease or defect, and about duress. Lastly, Mr. Black will deal with submissions the defence have made concerning the crimes which the prosecution alleges were committed during the 4 charged attacks on the camps at Pajule, Odek, Lukodi, and Abok, and about wider evidential issues which arise from those submissions. Your Honours, in order to put those remarks in context, I am first, very briefly, going to outline the nature of the prosecution evidence which is before the Chamber as it relates to the 70 charges which the prosecution brings against Mr. Ongwen. And I think it may be helpful to start at the end of that list of charges. And I'm going to start with counts 69 and 70, which relate colloquially to crimes involving child soldiers. The prosecution say that the evidence in this trial has proved that at the time of the crimes which the prosecution allege against Mr. Ongwen, the Lord's Resistance Army, led by Joseph Coyne, was engaged in a non-international armed conflict with the aim of overthrowing the government of Uganda. The LRA's fight was not only against government soldiers. It included, say the prosecution, widespread and systematic attacks on the civilian population. The LRA had a long-standing policy of abducting and conscripting children, including children under the age of 15 years, into its ranks. That policy was implemented in all its units and in the Senior Brigade between the 1st of July 2002 and the 31st of December 2005. That, of course, is the charged period on which this trial is focused. That period was no exception. Boys were abducted to become LRA fighters, and girls were abducted to become forced wives and domestic servants or babysitters known as ting-tings. Every unit in the Senior Brigade had children under 15 in its ranks during the charge period, and abductions were a standard part of Senior Brigade's operations. Children, including children under 15, were abducted to fill the ranks of the brigade during the charged period. The preferred age for the abduction of boys was around 12 years, although boys sometimes as young as 8 or 9 were abducted as well. After abduction, boys usually underwent a ritual and were beaten as part of their initiation into the LRA. They were trained with weapons. They were taught about LRA rules. They were assigned to particular fighters, often the ones who had abducted them. When they were deemed sufficiently reliable, abducted boys, including boys under 15, were armed with guns. They were used as escorts to commanders in the Senior Brigade. They were placed in observation posts. They acted as guards and carried food, weapons, and ammunition. They took part in attacks on civilians, in ambushes, and in battles with the Ugandan army, the UPDF. And they were used to kill, to pillage, and to abduct. Mr. Ongwen was a member of Senior Brigade's leadership throughout that charged period of 42 months. First as battalion commander, and from March 2004 onwards as the commander of the whole brigade. Together with his co-perpetrators, other members of Senior Brigade leadership and Joseph Coyne, he pursued a common plan of abducting children in northern Uganda and conscripting them into the Senior Brigade to ensure a constant supply of fighters. As a result, children, including children under 15, were conscripted and used to participate actively in hostilities. Mr. Ongwen, amongst other things, ordered abductions, monitored the training of children, himself used children under 15 as escorts or part of his entourage, and deployed children on military operations. He regularly interacted, as your honours have heard, with those children. On occasion, he even specifically inquired about their ages. He knew full well that amongst them there were those who were under 15. I want to turn now to the charges which relate to the attack on the Pujule camp. That's counts 1 to 10. The prosecution say that the evidence in this trial concerning the attack on Pujule has proved beyond reasonable doubt that in the days leading up to the attack, Vincent Otti, deputy commander of the LRA, ordered other commanders to meet him in Padere in northern Uganda. Mr. Ongwen responded to that call and he joined Otti on the 5th of October 2003. Shortly before the 10th of October 2003, Otti, Mr. Ongwen and other senior commanders agreed to attack the IDP camp at Pujule. LRA fighters converged about 10 kilometers east of Pujule, near a place called Wanduku, and it was there that the fighters were selected to participate in the attack. Mr. Ongwen instructed some of his subordinates to select LRA fighters to form part of the attacking force. At dawn on the 10th of October 2003, LRA fighters attacked the camp. They were divided into 4 groups. The overall commander on the ground in charge of those groups was a man called Raska Lukuya. Mr. Ongwen's role was to lead a group to attack the trading centre at Pujule. The attack caused havoc. Civilian inhabitants were murdered and they were abducted in their hundreds. LRA fighters in Mr. Ongwen's group broke into shops and civilian homes. They pillaged a variety of items. They abducted civilians at gunpoint and forced them to carry those looted items. Civilians who were unable or unwilling to carry items given to them were either beaten or ultimately killed. And Mr. Ongwen was present at the centre of the camp when this occurred. After the attack, Mr. Ongwen and the LRA attackers returned to a rendezvous point. We've referred to them consistently as RVs. And they took with them the items they had pillaged and a large number of civilian abductees. Ultimately, the LRA released most of the abducted civilians, but they kept the younger ones to serve as new LRA fighters or forced wives, or for the younger girls to act until they grew older as domestic servants, known in the LRA as ting-tings. I turn now to the crimes which arise out of the attack on the camp at Odek. That's counts 11 to 23. The prosecution say that the evidence in this trial has proved beyond reasonable doubt that in April 2004, Joseph Coyne ordered the LRA to attack his own birthplace, Odek, which is in southeastern Gulu district. Why? Because the people there did not support the LRA. On the 28th or the 29th of April of 2004, Mr. Ongwen, commander of the LRA's Senia Brigade, gave orders to fighters under his command to attack the Odek IDP camp and to kill and to abduct civilians and to pillage their food. After briefing the fighters, Mr. Ongwen personally led the attack on the camp on the 29th of April, accompanied by other senior Senia Brigade commanders. They split into groups as they approached the camp. One group attacked the barracks, killing soldiers and burning the building. A second group moved through the camp to the trading centre. They murdered civilians. They burnt civilian homes. They abducted civilian men, women, and children to carry away the pillaged food and other goods. Some of those abducted civilians were later killed by the LRA. Others were conscripted into the ranks of the LRA as fighters or distributed as forced wives or ting-tings. And on the 30th of April and the 1st of May 2004, Mr. Ongwen reported the results of the Odek attack by radio up the chain of command to Joseph Coyne and Vincent Otti. His voice can be heard describing the results of the attack and answering questions about how complete the destruction had been. I turn now to the charges arising out of the attack on Lukodi, counts 24 to 36. The prosecution say that the evidence in this trial has proved beyond reasonable doubt that sometime before the 19th of May of 2004, Mr. Ongwen ordered LRA fighters to attack the camp at Lukodi and to target civilians. The orders he gave included instructions for killing the inhabitants and burning and looting civilian properties. In preparation for the attack, Mr. Ongwen handpicked and briefed fighters from the Sania Brigade, which he commanded. He also obtained a smaller group of fighters from the sick bay of a different brigade, the Gilva Brigade, and commandeered them to join the attacking group. He selected Captain Alex Achaka from his brigade to lead the attack as the overall commander. But he did not go to the attack site himself on this occasion. It was the early evening when the attack began. Fighters under Mr. Ongwen's command attacked Lukodi camp and committed a series of crimes against its civilian residents. These included the murder of civilians, the destruction of their homes, the pillage of their belongings, and torture and enslavement of camp residents. Some of those abducted were later killed by the LRA. Others, again, were conscripted into the LRA ranks as fighters or forced wives. And after this attack, too, on the 21st of May, Mr. Ongwen made a preliminary report to Joseph Coyne, Vincent Otti, and other LRA leaders over the radio. His voice can be heard telling them that he had attacked the camp at Lukodi. He told them about the killing and the burning of homes which his fighters had carried out. And on the 24th of May of 2004, once he'd received a first-hand report from his commander on the ground, and his fighters had returned from the camp, Mr. Ongwen made a supplementary report on the radio and confirmed his responsibility for that attack. Next, I turn to the charges arising out of the attack on the camp at Abok, counts 38 to 49. Prosecutions say that the evidence in this trial concerning the attack on Abok has proved beyond reasonable doubt that on the 8th of June 2004, at the Atto Hills, Mr. Ongwen appointed one of his subordinate officers, a man called Kalalang, to select and lead LRA fighters from the Sania Brigade in an attack on the camp at Abok. Mr. Ongwen ordered the attackers to shoot anyone found there, to abduct people, to collect food, and to attack and burn down the camp and the barracks. Kalalang did indeed lead the fighters chosen for that attack. He ordered them to kill civilians by burning them or smashing their heads with clubs. He wanted to save ammunition. And armed with guns and pangas or machetes, the attackers descended on the camp in the evening at about 7:30. The Ugandan government soldiers and the local armed forces stationed at the camp were unable to protect the civilians living there, and they were chased away by the LRA fighters. And those fighters did just as they were ordered. They shot, stabbed, beat, and burnt civilians to death. They injured others. They pillaged civilian property and food. They destroyed civilian homes and property by setting them on fire. civilians were abducted and forced to carry the loot which LRA fighters had pillaged. And under threat of death, abducted civilians were taken out of the camp by their captors. Some were beaten, some killed, and others later recruited by the LRA in the ways that I have described previously. In the early hours of the following day, government soldiers pursued the LRA fighters, but they managed to rescue only a few of the abducted civilians. Mr. Ongwen later met those fighters and the civilians they'd abducted at a rendezvous point at the Atto Hill, where he was informed of the results of the attack. And on the 9th and 10th of June 2004, Mr. Ongwen reported the successful attack that his fighters had carried out over the radio to Raska Luquia, Vincent Oti, and Joseph Coyne. Again, his voice can be heard on the recorded radio communications, confirming having sent out a deployment that was shooting at anything that was moving. Your Honour, there are 4 counts, 10, 23, 36 and 49, which are associated with those attacks. They are counts of the crime of persecution. The prosecution say that the evidence in this trial has proved that during that charged period, 1st of July 2002 to the end of December 2005, the LRA were targeting for attack civilians in northern Uganda, whom they considered to be supporting the Ugandan government. They didn't need to be showing overt partisanship. It was enough, so far as the LRA was concerned, for them to reside in the government-established camps for the LRA to consider them to be supporting the government. Coyne and other senior LRA commanders issued regular orders that civilians in those camps should be targeted. And Mr. Ongwen, the evidence establishes, was well aware of the LRA's persecutory campaign. His position of authority gave him regular access to radio communications. He endorsed that campaign, and that's demonstrated by his words and actions throughout the charged period. And of course, of particular relevance to this trial, Mr. Ongwen, say the prosecution, furthered the persecutory campaign of the LRA during those 4 charged attacks. And taken together, the prosecution say, this evidence leads to the inevitable inference that Mr. Ongwen acted with discriminatory intent in respect of the attacks on the 4 camps at Pajule, Odek, Lukodi, and Abok, thereby committing the crime of persecution in each case. I want to turn now to crimes which Mr. Ongwen committed, the prosecution say, in a rather different way, in a very much more direct way. I want to turn to the sexual and gender-based crimes which the prosecution say he directly perpetrated. And of course, this is counts 50 to 60 in the document containing the charges. The prosecution say that the evidence in this trial has proved beyond reasonable doubt that during the charged period, Mr. Ongwen directly perpetrated sexual and gender-based crimes. The victims of those crimes were the 7 witnesses whose evidence is before the chamber in this trial. Some of them were distributed to him, others he personally abducted. He enslaved all of them. He subjected them to domestic servitude. He tortured them, he raped them, and he sexually enslaved them. He forcibly married, confined, and continued to rape them for the period they were under his control, sometimes resulting in their forced pregnancy. Although the rape and enslavement of some of these witnesses occurred outside the charged period, their evidence, the prosecution say, provides vital context for the chamber's understanding of the coercive environment that existed in Mr. Ongwen's unit during the charged period. Those witnesses didn't freely consent to take Mr. Ongwen as their sexual partner. They didn't consent to the subsequent activity. They had no choice. Any act of resistance resulted in beatings and threats of death. None of them was allowed independently to determine her marital partner or to exercise her choice in starting a family. None of the traditional rituals of marriage was observed. These girls and women had no reproductive autonomy, and the forcible imposition of marriage has contributed to the stigma they have suffered since escaping from Mr. Ongwen and from the LRA. And finally, Your Honours, I turn to other sexual and gender-based crimes which Mr. Ongwen did not perpetrate directly, but through others under his command. That's counts 61 to 68. The prosecution say that the evidence at in this trial has proved that sexual and gender-based crimes, of which the victims were women and girls, was a defining feature of the LRA as a whole. You've heard evidence about how over decades, but including the charged period of 3.5 years, thousands of women and girls, often when they were still children, were abducted, distributed to LRA fighters and commanders, and subjected to the LRA's regime of sexual and gender-based violence. The prosecution's case is that just as in other LRA units, hundreds of women and girls were abducted, forcefully kept, and victimized in Mr. Ongwen's Senior Brigade throughout the charged period. Women and girls in his brigade were abducted, distributed to fighters and commanders with no choice on their part. According to their age, they were either enslaved to carry out household tasks until they were older, or raped and sexually enslaved as the forced wives of fighters under Mr. Ongwen's command. They were unable to refuse these roles that were forced upon them. Resistance resulted in violence or death. These crimes were committed in an environment of fear, threat, and coercion. And again, many of those victims continue to suffer the consequences and stigmatization to this day. The prosecution say that the evidence has clearly demonstrated that Mr. Ongwen was at the heart of those crimes committed in the Senior Brigade. As the commander first of the Oka Battalion and later of the entire brigade, he facilitated, sometimes actively ordered, the abduction of women and girls. He played a key role in their distribution. Sometimes he chose them for his own use. More often, he distributed them to his subordinates as a reward or as an incentive. Your Honour, before I hand over to Mrs. Adebayo, I want to respond to what the defence has said about Dominic Ongwen's own victimhood. In the closing brief, they put this in various ways. In paragraph 6, they assert that the case of Mr. Ongwen is a case of conflict between the government of Uganda and the LRA. Mr. Ongwen is only a victim. In paragraph 12, they state boldly, Mr. Ongwen is a victim, not a perpetrator. And in paragraph 20, they say, once a victim, always a victim. So, what does the prosecution say about this? Have we charged the wrong man? How come we're picking on an individual who was himself abducted somewhere between the ages of 9, as the defence have contended for, or 14, as Mr. Ongwen himself told this court when he first appeared before it? Your Honours, when we opened this trial, the prosecutor of the court addressed this matter head-on, in clear terms. And the prosecution's position is still, perhaps, best captured by what she said 3 years ago. But in the light of the defence's observations, it may bear restating. And briefly, I will set out the prosecution's position. We are not here to deny that Dominic Ongwen was a victim of abduction. And no doubt, his treatment when he was first abducted was similar to the atrocious treatment that we have heard was handed out to young abductees in the units that he himself conducted many years later. But the defense line that this should somehow make him immune from being held to account for the atrocities which he himself committed is untenable. The phenomenon of the victim who becomes a perpetrator may be a novel one in international criminal courts, but for those who practice criminal law in a domestic setting, it's mundanely familiar. Sometimes the connection is quite direct, such as when criminal sex offenders turn out to have been themselves the victims of sex abuse as children. It's a tragedy, no one disputes that, but equally no one suggests that they are therefore relieved of responsibility for their own crimes. Violent criminals have also often been victims of violence themselves, whether as children or as adults. And again, that is not to be ignored on a human level or even when determining punishment. But it can't be the case, as the defense seems to suggest, that such people have a lifetime free pass to commit crimes just because crimes were committed against them at some point in the past. In the end, the focus of a criminal trial, whether it's held here at the ICC or in a small district court in one of the state's parties, is not on the goodness or the badness of the accused person. It's on the criminal acts which he or she has committed. The focus isn't on whether one side or the other characterizes that person as a victim or a perpetrator, or perhaps more realistically recognizes that many wrongdoers answer to both descriptions. The prosecution has proved what Mr. Ongwen did and why the law should hold him accountable. He wasn't the victim of those crimes, and the court has heard about the impact of those crimes on the many people who were their victims. The court will decide whether he is guilty of the crimes with which he stands charged. If he is, then the question of his victimhood, a decade or more before those charged crimes, is one which may have to be considered again on the day of sentence. As I hand the floor to Mrs. Adeboyejo.
He shut the door. He asked me to undress. He undressed me as well. He asked me to spread open my legs. He took hold of his penis. He put it in my vagina. And he started forcefully having sex with me. I started crying. I was screaming, and my voice was really loud. He asked why I was crying. He told me that if I continued crying, he showed me his gun. The gun had something sharp on top of it, like a bayonet. I felt like my whole body was being torn apart. He was actually having sex with me in the anus as well for a very long time. The testimony of Mr. Ongwen's first wife, P227. Mr. President, Your Honors, the evidence that Dominic Ongwen personally committed sexual and gender-based crimes against civilians during the course of violence by the Lord's Resistance Army in northern Uganda is compelling. The slide before you is an example. But the defense, who challenged this witness, mainly on the anal penetration aspect of what she said, argue that Mr. Ongwen is not guilty of crimes against this witness or any of the other 6 witnesses who gave similar account of how they were the direct victims of his attacks on them. They argue that he did not intend to commit these crimes. They appear to argue that he cannot be blamed for what he did because of his poor mental health when he raped these witnesses. They also argue that he was acting under duress, that the hearings at which these women testified were procedurally defective, that the geographical parameters of the charges were not clearly specified, and that the witnesses were confused during the Article 56 proceedings. Your Honors, I want to look at these various aspects of the defense's claims. The prosecution's case is that Dominic Ongwen personally committed different types of sexual and gender-based crimes, including rape, forced marriage, sexual slavery, and forced pregnancy against 7 women, P99, P101, P214, P226, P227, P235, and P236. He not only personally committed these crimes, but he also made fighters of his senior brigade, of which he was commander, carry out similar brutal crimes. For his acts of enslaving, torturing, humiliating, and degrading the women, the prosecution.
I get a notice from the interpreters that you are a little bit too fast, so please slow down a little bit and take your time. Thank you.
Thank you, Your Honors. The prosecution is also charging him with enslavement, torture, and outrages upon personal dignity. The defense suggests that Mr. Ongwen lacked the intent to carry out these crimes, and that he only carried them out under duress because he was afraid of Mr. Coyne. Nothing could be further from the truth. The evidence of P226 makes it clear that the defense suggestions are untenable. P226 was a 7-year-old child, still in her school uniform, when she was abducted by soldiers under Mr. Ongwen and was taken to Sudan. In Mr. Ongwen's home, P226 was a ting-ting. As you heard, ting-tings are young girls assigned to help run households and care for children. As a ting-ting, P226 was made to carry out domestic chores, such as fetching water, digging the garden, and collecting vegetables for cooking. There is no doubt that this was her role. she was not challenged about it. And defense witness D13 confirmed her presence as a first wife to Mr. Ongwen during the charged period. When the time came for P226 and her fellow abductees to be distributed, Mr. Coyne, as the Supreme LRA commander, sent his escorts to fetch her. Mr. Ongwen refused to release her. He hid her under his bed. He said he found her and he gets to keep her. It's either she's divided in two or he would kill her rather than let her go. Mr. Ongwen wasn't under any duress. He was boldly defying Joseph Coyne. Mr. Ongwen did not hide P226 under his bed for 1 day or two. No, he hid her for a whole month until he was able to transfer her to another location. The suggestion that his action was lacking in intention is unrealistic. He kept her, he hid her, and eventually raped her when she was 10 years old. He was not afraid to set his will against Mr. Coyne and oppose him. And the manner of the rape is equally eloquent concerning the intentional nature of Mr. Ongwen's conduct towards P226. He first demanded sex with her when she was about 10 years old. According to her testimony, she had seen girls coming out of Mr. Ongwen's house crying, but she did not understand why, because she was too young to understand. Mr. Ongwen asked her, a 10-year-old child, for sex. She refused because, according to her, quote, she was disgusted, end quote. He then set his escorts to beat her continuously for a week until she capitulated. She was so young and so small that he had to lift her onto the bed to rape her. And when she started to scream, he threatened to kill her if she continued to cry. In the aftermath of the rape, the witness stated, quote, I could not get up. I went and I had a bath because I was bleeding. I was bleeding a lot, end quote. Your Honors, those are not the actions of a man who had no intent or who was afraid of Mr. Coyne. If that was the case, he could have kept her in the room and not raped her. But he did rape her. He planned it, had planned it for some time, fully intended to carry it out, and he did. This account and the testimony of other women whom Dominic Ongwen regarded as his wives were hardly disputed in cross-examination. I have drawn your attention to the dispute concerning the details of P226's rape. In the defense closing brief, they deal with the counts concerning these 7 women in a scant 11 paragraphs, para 472 to 482. No dispute with the accuracy or honesty of their testimony is raised. Instead, In para 480, they portray Mr. Ongwen as the victim of rules and regulations concerning sexual relationships. But it was Mr. Ongwen who had the power to release the women he regarded as his wives from the misery of their enslavement as wives in the bush. Indeed, he did release one of the first wives, P101, after she had spent about 8 years in captivity as a first wife and borne him 3 children. Your Honors, I'm going to ask a picture to be put on the screen, but it's not to be shown to the public. It's just going to be in the courtroom because it's confidential. So on the screen, Your Honors, is a picture of Mr. Ongwen between 2 women. P101 testified that she is the woman carrying her first child by Mr. Ongwen. P101 appeared on Dwog Pacho radio program shortly after her release and thanked Mr. Ongwen for releasing her. But she plainly thought he could have and should have done more to release more of the women he regarded as his wives. She calls some of the first wives by name. She describes their horrendous suffering and urged him, in fact, begged him to do so. There was clearly no doubt in her mind, as she directed her appeal at him, that it was Mr. Ongwen and not Joseph Coyne who had this power. This was a contemporaneous account, powerful evidence that Mr. Ongwen had both the knowledge and the intention to commit the crimes he did by his continuing conduct towards these women. Your Honor, still on the subject of intention, the defense argue that Dominic Ongwen's capacity to control his conduct had been destroyed by his mental illness. More will be said about this later today. But for now, I just want to note something which is nowhere acknowledged from the beginning to the end of the defense closing brief. Specifically, there is no evidence on the record to support that Mr. Ongwen's state of mind was affected at the time of the sexual and gender-based crimes. Not even the evidence on record from the defense mental health experts supports this assertion. Instead, D42, one of the defense mental health experts, made it clear that the defense experts were not instructed to and did not explore Mr. Ongwen's state of mind at the time of the alleged sexual and gender-based crimes. He said, and I quote, "The brief given to us was not sexual offenses. The brief was given to us for non-sexual offenses," end quote. So, in respect of these crimes, the notion that Mr. Ongwen did not act with the intention required by the law because of mental illness simply does not and cannot succeed. So where are we? The dispute about the facts has to fall away, as we have seen. And because we oppose their claim that Mr. Ongwen be excused from criminal responsibility by virtue of mental illness, the defense have now fallen back onto the claim of duress. They want to persuade your honors that after having caused these young girls to be beaten into submission and then having brought them to the privacy of his tent, it would have been impossible, on the pain of death, for him to have said quietly to them, "Actually, I'm not so wicked and monstrous as to rape a young girl like you. I've only done this to satisfy Joseph Coyne. But if you lie here quiet and safe, we can pretend in the morning that we had sex." He didn't do that. He didn't say anything like that. He was not compelled to rape them. If it was so, Mr. Ongwen would not have told one of his subordinate officers that two other female witnesses whom he later rapes were, quote, growing very well and were almost ready for trying, end quote. The witness explained, quote, when he said they were almost ready for trying, that meant they were almost ready for having sex, end quote. Your Honors, Mr. Ongwen carried out these sexual and gender-based crimes knowingly and intentionally to gratify his own desires. I will now turn my attention to the challenge to the Article 56 proceedings discussed by the defense in their brief. The defense are well aware that they have no meaningful challenge to the sexual and gender-based crimes directly perpetrated by Mr. Ongwen, as we have seen. The testimonies of the brutal rapes, sexual slavery, forced marriage, and forced pregnancy of the first wives were never effectively challenged. The defense now seek to challenge these testimonies through technicalities, even though these allegations of procedural unfairness were addressed by the single judge when raised before the pretrial chamber. They allege that at the time of the Article 56 hearings, Mr. Ongwen was not put on notice of the charges for which the evidence of the first wives were taken. This is not a new complaint, Your Honors. The defense raised it in filing 259 when they objected to the prosecution's application for the Article 56 hearing. But the defense challenge, if upheld, would undermine Article 56 and render it ineffectual. It would mean the article is only operative in the brief window between the confirmation of charges and the start of the trial. And this is precisely why the single judge of the pretrial chamber rejected the defense submissions, just as the prosecution is urging you to reject it now. The purpose of Article 56 is to permit the evidence of witnesses to be used in trial proceedings, which may take place years after the testimony was given. It is for each trial chamber, in the circumstances of the particular case, to decide whether it is fair to have regard to such testimony. The circumstances here are very clear. Mr. Ongwen and his lawyers had ample notice of what the witnesses were going to say because their statements were disclosed to him prior to their testimony. These 7 witnesses were testifying about brutal and painful events which personally involved Mr. Ongwen. He was in a position, perfect position, in the courtroom with his lawyers when they testified to challenge their accounts and to suggest that their testimonies were faulty or false. He did not do so. The prosecution therefore submits that the knowledge of the precise legal characterization of the charges against him would not have helped him. and it was not required by law. The other defense challenge I wish to address is that the geographical parameters of the charges related to P99, P101, and P214 were not clearly defined. Your Honors, the charges related to these three individuals, all of whom were directly victimized by Mr. Ongwen himself, are crystal clear, not only with regard to the temporal scope, but also, contrary to defense's submissions, their geographical scope as well. For each of these three individual victims, the confirmation of charges decision, having incorporated the factual allegations regarding the contextual elements in paras 66, 72, and 81 of the dispositive part of the document containing the charges, clearly specified the geographical scope of the charges. With regard to P99, at paragraph 67 of the confirmation of charges decision, the chamber specified, and I quote, "The conduct alleged below continued uninterrupted in northern Uganda after 1st July 2002 until P99's escape in September 2002, end quote. Similar language was used with regard to P101 and P214 in paragraph 73 and 82 respectively of the confirmation decision. The defense presents no plausible explanations on how the above wording is not specific or clear enough. Furthermore, not only are the defense's arguments without any merits, they are also blatantly incorrect. At paragraph 37 of their filing 1603, 8 out of the 10 counts listed by the defense are incorrect. The charges confirmed against the accused, in as far as P99 is concerned, only relate to forced marriage and enslavement, which, as the confirmation of charges language clearly specified, continued uninterrupted in northern Uganda within the charged period. Your Honors, this leads me to the other defense challenge and the third point I wish to address. That the single judge's alleged failure to determine the status of the witnesses violated Mr. Ongwen's Article 67 1E rights. They allege the single judge misled and confused the witnesses when he said, and I quote, "I think a witness is a witness. It's not a prosecution witness. It's not a defense witness, but just a person who has come to tell the truth." And yet, Your Honors, the defense has taken exactly the same view as the single judge in these proceedings. Your Honors, the single judge was merely echoing the sentiments of Trial Chamber 7 in Prosecutor against Bemba, 4th September 2012, paragraph 23, where the chamber stated, and I quote, "At the outset, the chamber notes that the parties and participants do not own the witnesses they call to testify. Indeed, the witnesses do not belong to parties or participants. Witnesses are the property neither of the prosecution nor of the defense, and should therefore not be considered as witnesses of either party, but as witnesses of the court," end quote. Your Honors, at the time when the issue was first raised, the defense themselves were fully in agreement. They said they were, I quote, highly impressed, unquote, with the direction and ruling of the court. The defense said, and I quote them, "It doesn't matter whether it's for the prosecution or for the defense. All that is important is that the truth has been told, and it is for the purpose of helping court to arrive at the correct decision," end quote. Your Honor's counsel was referring to witnesses P235 and P236, who were said to have been expressing concern about appearing as witnesses before the court. Counsel for the defense confirmed this. Again, let me quote the defense. "Because from what I glean from what has been said here, it would appear they seem to be under the impression that they are coming to give evidence against the accused, or I mean the suspect. And yet, this is not what the court is about. The court is about evidence in its own right, telling the truth, what the witness has to say. It doesn't matter whether it is for or against the witness." Counsel meant Mr. Ongwen, of course. "It's just about what the witness knows about the case," end quote. Mr. President, Your Honors, that was the defense position 5 years ago. They emphasized the truth-seeking function of the court. They said they appreciated the collegiality with which both sides had conducted the proceedings. They even offered, in that same spirit of collegiality, to contact the witnesses and persuade them to testify. The defense cannot now be heard to try and revise history by suddenly alleging that they were deprived of being the party to bring these witnesses to court, or that the witnesses would have given a different testimony. Presumably, they mean less damning testimony for their client if they had appeared under the label of defense witnesses. The witnesses, first wives of Mr. Ongwen, came before this court, told the truth about their experiences, and their evidence proves beyond reasonable doubt that Mr. Ongwen committed the sexual and gender-based crimes. I thank Your Honors for listening.
Your Honours, I want to address 5 topics arising from arguments made by the defence in their closing brief. I want to address the allegations the defence makes that Mr. Ongwen's fair trial rights have been violated. I'll speak about submissions of law which they've made concerning modes of liability which describe Mr. Ongwen's involvement in the crimes alleged against him. I'll deal with defence suggestions that the LRA radio transmissions which the Ugandan authorities intercepted and recorded in logbooks or sometimes on cassette tapes are unreliable, mostly irrelevant, unauthenticated and inadmissible. And I'll demonstrate the falsity of those allegations. I will tackle the defence's confusion about the relationship between mental illness and duress, and note a number of other errors in their assessment of the expert medical evidence. And lastly, I will deal with the defence's bold assertion, in the light of the fact that the Chamber has heard from dozens of witnesses who escaped from the LRA, that it was effectively impossible to do just that. I note that there are 25 minutes till our normal break. I shall certainly be speaking for longer than that period of time. May I pick a convenient point when we are approaching 11 o'clock?
Do so as you wish.
I'm very grateful. So I turn first to the question of whether this trial has been fair or not. Defence devoted about 20% of their 200-page brief, about 40 pages, to alleged fair trial violations. And for the most part, they're complaining about decisions which the trial chamber has already made. And I'm not going to spend much time revisiting the prosecution's submissions in respect of those matters, or rehearsing the reasons for the chamber's findings. I'm going to focus on two topics. First, the defence's allegation that the trial chamber has discriminated against Mr. Ongwen on the basis of a purported mental disability. It's at paras 120 to 146. And second, the purported violation of Mr. Ongwen's right to counsel and right to remain silent prior to his handover to the ICC. That's at paragraphs 41 to 62. The defence say that each of these purported violations means that rather than continuing on to reach a verdict based on the evidence that you've heard, the Chamber should never have started hearing that evidence, and should now, as the lawyers have it, stay the proceedings and leave the trial in suspended animation. So, is there any merit in the defence's claim that the Chamber has, and I quote, a disability blind spot? That's at paragraph 146. There is none. First, the defence has not established that Mr. Ongwen is indeed mentally disabled. There's been no judicial finding on whether he currently suffers from a mental health condition at all. And the evidence in this regard is mixed. At least two of the prosecution experts were not satisfied that the evidence supports the diagnoses attributed to Mr. Ongwen. Those experts suggest that there are strong reasons to believe that Mr. Ongwen is malingering, or to put it more bluntly, faking bad. They suggest that the doctors who've made those diagnoses have failed to test that possibility in any serious way. They note that until the intervention of the doctors called as witnesses by the defence, the opinion of the psychiatrist who was caring for him in the detention unit was that, and I quote, "His perception is clear, there are no cognitive disorders." And your honours will recall that elsewhere that same psychiatrist noted that although he exhibited some symptoms of post-traumatic stress disorder, Mr. Ongwen's condition was, and again I quote, "stable, with no mental health condition." In the closing brief, the prosecution have set out in detail the reasons why Mr. Ongwen's own account of his mental condition, which is almost exclusively the source used by the defence experts to come to their conclusions, is unreliable. And second, even if Mr. Ongwen is currently suffering from mental illness or from the symptoms of such illnesses, the defence has failed to establish in any concrete way what prejudice he has suffered. Mental illness by way of depression, anxiety, personality disorder, and other conditions is rife amongst those who appear before the criminal courts. The courts make, as this chamber has, accommodations to allow for this. But the possibility that they are suffering from mental illness doesn't function as some kind of protective cape to shield an accused person from all of the rigours of a criminal trial. It's for that person's doctors and lawyers, Mr. Ongwen is plentifully equipped with both, to bring to the court's attention the specific ways in which disorders from which he suffers may impact on the process. And it's for the court to make such accommodations as are necessary. The defence raises three specific issues as examples of the Chamber's purportedly discriminatory approach. None of them, the prosecution submits, is valid. The first example is the purported illegal plea. Essentially, they are arguing that the Chamber's finding that Mr. Ongwen understood the nature of the charges was wrong, and that its subsequent action in permitting him to enter pleas of not guilty is therefore, as they describe it, illegal. And the defence's position appears to be that, in fact, I quote, a mentally disabled defendant cannot enter a plea because he lacks the capacity to understand the charges. And here we see an example of what might be termed the defence's concept creep. They start from the premise that Mr. Ong...
I'm again reminded that you perhaps speak a little bit slower.
The defence start from the premise that Mr. Ongwen is mentally disabled. But they present no evidence to persuade the court that his capacity to understand the charges is lacking. And it's important to recall that while they rely on diagnoses provided by their own experts and by the court-appointed expert, Professor de Jong, they actually wish the court to ignore the findings which Professor de Jong made about Mr. Ongwen's condition. Professor de Jong reported on Mr. Ongwen's condition as follows. It's at page 4 of his report, and I quote, "Consciousness is clear, and he is orientated in time, orientated vis-à-vis his environment and himself. He has a good attention span and maintains his concentration after hours of interviewing. Conscience and superego functions are developed." Those were the findings of the independently appointed court expert. The defence is suggesting that the Chamber must ignore those findings. For them, any person diagnosed with a mental health condition or symptoms of a mental health condition is mentally disabled. And therefore, a person with a mental health condition is de facto automatically incapable of entering a plea in criminal proceedings without any consideration of that issue separately. Not for the first time, the defence adopts a position which is at odds both with the law, with the evidence in this case, and frankly, with common sense. Mental illness doesn't prove that a person is unfit to enter a plea, any more than physical illness does. The existence of illness is just the first part of the issue. Far more important is whether that illness prevents the accused person from understanding the essence of the case against them and from giving instructions to their lawyers. The defence argues, paragraphs 75 and 76, that Mr. Ongwen's words at the outset of the trial were a demonstration of the fundamental lack of understanding which he had of the charges. Your Honours will recall what he said, but I'm going to quote it. It's brief. He said, "I do understand. I did understand the document containing the charges, but not the charges, because the charges I do understand as being brought against the LRA, but not me, because I am not the LRA. The LRA is Joseph Coyne, who is the leader of the LRA." And paragraph 5 of the defence closing brief echoes that language. It says, and I quote, "The defence starts from the premise that this case is against the LRA, not Mr. Ongwen." Well, I won't spend time disputing the accuracy or otherwise of that statement, but I do remark that Your Honours will be familiar with the phenomenon of accused persons denying charges, blaming another person or an organisation or perhaps the society that they live in, blaming those persons or bodies for being the real criminal. Mr. Ongwen's remarks don't betray any lack of real understanding. They're an attempt to shift the blame. And the trial chamber was quite right to understand those remarks as his way of disputing his responsibility for the alleged acts, rather than any indication that he didn't understand what he was being accused of. He clearly did, and he was clearly telling the chamber that they'd got the wrong man. Let me move on to the second example, which the defence uses. Their claim that the sitting schedule which the trial chamber adopted is unfair. They argue that the trial chamber adopted a discriminatory approach to Mr. Ongwen in that way. Specifically, they say that the chamber failed to implement a recommendation of the ICC Detention Centre medical officer for 8 months during the trial, because the chamber didn't guarantee a time-out day on Wednesday. Prosecution's submissions are this was no discrimination. In deciding to adopt a flexible 4-day schedule, trial chamber acted clearly within the scope of its discretion and took into account the medical officer's recommendation, as well as other pertinent factors. It's the trial chamber, of course, we would say, that has the ultimate responsibility for ensuring that proceedings are both fair and expeditious. In managing a trial, courts are inevitably required to balance a number of different, often competing considerations. The health status of the accused is just one of those factors. It's a very important one, no doubt, but it is not one which trumps all other considerations. The input of the medical officer is important for the trial chamber, but the trial chamber isn't bound by every recommendation that's made in that regard. The medical officer didn't specify in which particular ways Mr. Ongwen's capacities would be affected by the court occasionally sitting on Wednesdays. Rather, he referred in general terms to a potential possibility of, and I quote, alleviating the pressure experienced by Mr. Ongwen. The essence of the recommendation was based not in Mr. Ongwen's particular case, but in the medical officer's general experience. And again, I quote, 5 court days in a row is generally too much for a detainee with serious mental or physical health issues. In fact, the trial chamber's departure from the Wednesdays off suggestion was minimal. And the chamber, I beg your pardon, and the defence has plainly established no real prejudice. During the relevant period, firstly, the trial chamber never sat for 5 days in a row. In fact, it sat on just 5 Wednesdays in total over those 8 months. And on one of those occasions, the court only sat 2 days in the week. It's relevant to note that 3 of the Wednesdays concerned were days when the court had scheduled the testimony of expert witnesses, all 3 of whom themselves were medical professionals with complicated schedules and responsibilities to their own patients. The defence has made no concrete showing of harm to Mr. Ongwen's ability to prepare and to conduct his defence. What is it, I would ask rhetorically, that he has been unable to do, or to do less well than he would have done if there had been no sitting on those Wednesdays? If Mr. Ongwen was impacted by sitting on those days, if the questions asked of those witnesses would have been different or better had they been asked on another day, and if this was something which the defence considered as a significant defect in the presentation of their defence, no doubt they would have sought to recall those witnesses, perhaps through electronic means, to ensure that all matters had been fully dealt with. Lastly, on this topic of the sitting schedule, I would submit it's important to look at the surrounding context. Given the measures taken throughout this trial, it's clear the Chamber didn't discriminate against Mr. Ongwen on the basis of any ill health. Among other things, the trial chamber appointed Professor de Jong to examine Mr. Ongwen and to provide specific recommendations on the necessary treatment or measures to be taken. The chamber has cancelled sitting days when the medical officers in the prison have indicated that Mr. Ongwen isn't feeling well. And perhaps most significantly, the chamber has established a screening mechanism in collaboration with the registry, in whose care, of course, in the detention unit Mr. Ongwen sits. A screening mechanism to ensure that Mr. Ongwen's health is monitored on an ongoing basis throughout the trial. The third example to which I want to turn, and I think I will deal with this and then pause if I may, is the Chamber's rejection of a request to order a second examination under Rule 135. Just to explain to the audience, Rule 135 gives the Chamber the power to order a medical examination and is the order the Chamber deployed when it asked Professor de Jong to report, as he did in the terms that I have described. Perhaps not surprisingly, given his observations about Mr. Ongwen's clarity of consciousness, well-regulated social orientation, excellent attention span, at no stage in that first report did the professor suggest that Mr. Ongwen, despite the mental illness which he had diagnosed, was unfit to take part in the trial, which the professor knew was about to begin immediately. But the defence asked for a second examination under that rule shortly before Mr. Ongwen might have chosen to give evidence, and the Chamber refused that request. Prosecutions addressed that issue in writing. I'm going to touch on it only briefly. In sum, we say the trial chamber correctly and fairly concluded that there was no new basis on which to order an additional examination, no new evidence that Mr. Ongwen was unable meaningfully to exercise his fair trial rights. The defence assertion that Mr. Ongwen's right to testify has been violated by the trial chamber's decision not to order this second examination under Rule 135 is, we would suggest, in essence, an attempt to relitigate the question of fitness to stand trial. The trial chamber pointed out, and I quote, "The fact that the accused has to decide whether he wishes to testify is not a new circumstance. In any case, the question of whether to testify or not is one of litigation strategy, not medicine. What the defence was really aiming for, the prosecution suggest, is a procedural ground to which they could ascribe the tactical choice by Mr. Ongwen not to testify, so as to bolster the claims they make more generally about his poor mental health. Your Honours, we submit that the fact that Mr. Ongwen or his lawyers assert that his poor mental health prevents him from being tried fairly is not enough. There has to be evidence to that effect. Mr. Ongwen at all times has been under the care of mental health professionals at the ICC detention unit. They've expressed their concern at various times, and the chamber has weighed those concerns carefully and acted appropriately, sometimes suspending proceedings. But if those professionals had ever provided reasoned, expert opinions explaining why Mr. Ongwen was unfit in the long term to be tried, then the chamber would, no doubt, have taken action to investigate the matter further. And so far as has been made known to the prosecution, no such opinions have been provided. I'll pause there if I may.
You may. We have now a break until 11:30.
All rise. We will